Right, this is LAWS 12066 Land Law, and this is a feedback recording for the 30% assessment. Right, folks, so the 30% assessment was 3 questions, each of equivalent value at the end, each worth 10 marks. The first question was a policy style question, and the next 2 questions were problem-solving questions. Now, in the comments that I'm going to make now, I'm going to provide feedback on the assessment and what was revealed through students' assessments and what was being sought in the answers and responses. I have given, I think, fairly reasonable feedback on students' assessments. But the comments I want to make are not just in relation to the assignment, but I want to make them in anticipation of the exam, which is the final assessment worth 50%. Not insofar as the particular topics that were assessed in the 30% assessment are concerned, obviously, because they're not on the final exam, but I want to make some observations as I go along in terms of the style of question for you to think about and reflect upon in your exam preparations. So this is a sort of a feedback recording for the assessment, but also points, tips for the exam. Now, clearly the exam is in a different situation, different time constraint, handwritten and so on, but there are some techniques that I think it's important to emphasise and will stand you in good stead if appropriately applied in the final exam. All right, so the first question, as I said, was a policy style question, and it was pitched in a certain way. So it was clearly about caveats and priority notices, mechanisms for providing a means of protecting unregistered interests in different ways. Caveats are more longer standing than priority notices, which have been introduced as an amendment to the Land Title Act. But the question was not just about describing the 2 mechanisms, and you could walk through the various sections of the Land Title Act detailing what was a caveat, what did you need to establish a caveat of interest, and how did that work, and what were the requirements under the Land Title Act, timeframes, having to prosecute action, and so on, and also the various provisions or sections under Part 7A dealing with priority notices, formerly known as settlement notices, and what's the process there, and so on, and the various steps and stages, and what type of interests, primarily a purchaser or a mortgagee interested in lodging a priority notice prior to registration of their interest. So you could have done that, but that really wasn't what the question was focusing on, just a descriptive exercise. By the way, a little tip, Michael's tips, no question is ever about just a descriptive exercise. Surely that message is clear by now. No question, no assessment question, really, and truth, at least none that I set, are just about providing you an opportunity to describe the law, right, and walk through a description of the law. No, it's not about that. It's expected that you've got an understanding of the area of the law that's being assessed, and then you're showing how you can apply it back to the question. Okay. Now, in a policy style question or essay style question, I tend to call them policy style questions because I tend to set questions around areas of policy controversy or policy debate in the area that I'm teaching and the courses that I run, land law, property law, and often picking up on reform initiatives. Here's another tip, picking up on reform initiatives, and you've been given documents throughout the unit with good reference to those documents in various ways in my lectures and so forth, to reform initiatives or recent policy and now, documents issued, and all of those are on the Moodle website, and I'm not requiring you to go beyond materials. Again, looking forward to the exam from what I've provided you with. But this particular question, right, it asked you to look at these different mechanisms, caveat, priority notice, in the context of advances in e-conveyancing, and then these critical words, is it likely to supplant the use of the caveat? Okay, supplant meaning replace the caveat. Right? We like to use a range of language and terminology in law as we do. So needed to focus on that, right? You obviously needed to explain what these mechanisms were, how they work, distinguish them, because they're not the same and they actually don't do the same things exactly, right? And that point should have been brought out through a reference to the various provisions. On caveats, there's quite a fair bit of body of case law, and again, probably I would have liked to have seen in several students' responses a bit more on the case law, but selective, obviously given the parameters of the word length and so on. A lot of answers didn't make any reference to case law at all with regard to caveats. So where you're looking at a topic that has legislation and case law, there's a need for you to consider both, right? That's always important. Land law is replete with that, okay? Where, different topics, legislation, provisions of the PLA or the LTA and case law relevant, and as well as reform proposals and initiatives and so on. So you had to tackle this idea of, was it going to supplant the use of the caveat? So looking for what arguments you were looking in that regard, and in terms of, and also this focus on e-conveyancing. Okay. Now the other thing was that, again, you see that there was a statement, right, or quotation, whatever, and then required. What were you required to do? Well, you're required to prepare a presentation to the partners of your law firm. To the partners of your law firm. So that needs to be how you are structuring your response. If you didn't do that, and several students didn't actually, they just went ahead and talked about caveats and priority notices and didn't really bother about that this was supposed to be a presentation to the partners of the firm. Well, you weren't going to get a really strong outcome, of course, because you're not actually addressing the question, okay? Addressing the task at hand. Very important going forward in the exam. You've got part A, you have to choose one from two questions there. Focus on, yes, obviously the substance of the question which you're being asked to consider. You already know the topics that are being assessed in part A. What's the angle of the question? What are you being asked to do? If you're being asked to advise someone, you're being asked to do maybe make some briefing notes, being asked to maybe start the development towards maybe a law reform commission proposal, then you need to angle your answer in that regard. You need to think about, how am I going to angle my answer in that regard? Yes, I need to get across the material that's relevant, but I need to respond to the task at hand. That's really important, people. And the whole purpose of this exercise is to develop in you skills across a variety of contexts, because as lawyers of the future, you are going to be required to operate and function and deliver information and give advice and give presentations in a whole lot of different situations and contexts. You're not only ever going to be just advising your client. If you move into private law practice, yes, that'll be a bulk of what you do. Sometimes, though, if a client is an organisation, they might like you to come along and give a presentation on a new area of law to selected members of their organisation. That's a different type of skill set to giving written formal advice. And I suppose increasingly going forward, and I'll talk more about this when we get to question 2 and 3, clients are looking for things that are efficiently brought to them. And, in law school, we've got a bit of a hybrid going on here. So we're obviously giving you a scenario. We want you to go through the relevant law, discuss it, analyse it, and evaluate it and put it against the factual scenario. But if you're being asked to advise a client, it's very important to advise the client. Not forget that. Very important. In this context, you had to prepare a presentation to partners. Now, again, this could have been done as a multimedia exercise or as a written document. Had some very interesting multimedia presentations, both audio and vidcasts, and thank you for those that took up that challenge. Also had some very strong written documents in response to this question. But again, a lot of students just described the mechanisms. There was certainly a percentage of students that just forgot about this, that they were actually advising partners of a law firm. And again, you have to think a bit laterally here. Okay, so advising partners of a law firm. Now, I remember a few responses actually said, well, look, clearly these partners are going to come along and they're not all going to be property lawyers. Good, that's right. They're not all going to be property lawyers. What's going to make this presentation interesting for them? I can tell you what will make it interesting, not all the whistles and bells in terms of how you do the presentation. That's helpful. Yes, it is helpful to be interesting and engaging and dynamic if you're doing it in that way, particularly if you undertook it to do as a multimedia presentation. What will be the hook of interest will be how does it relate to what's important to them? And in this context, law firm partners, what are they interested in? They're interested in clients, they're interested in doing the best for their clients, they're interested in maybe generating more business. And importantly, they might be interested to see, well, you know, caveats priority notice, that's about property law. I'm not about property law. I'm a tax lawyer, or I'm a personal injury lawyer, or I'm a something else lawyer. Why should I be interested in this? Well, you've got to somehow explain that this is relevant because the truth is property transactions spill over into other types of areas, and the implications here, that can have relevance. So looking, when you're being asked to do a presentation to an audience, think about the audience and think about what will make it relevant, interesting, and appropriate for them. Certainly you had to, walk through the mechanisms and explain how they work and so on, but from that context. Now, the other thing was that, again, focusing on electronic conveyancing, most students said, yes, well, the introduction of priority notice mechanisms is partly a response to that. It's an amendment to the Land Title Act. It's not universal, not all jurisdictions have this, but Queensland does. But again, these further advances in e-conveyancing, well, many students commented on, well, efficiency, cost effective. They mentioned the cost differential between priority notice and caveats. Good. That's certainly interesting to the partners because that has a relevant implication for clients. And also, how you do it through the electronic conveyancing environment currently under PEXA. But of course, folks, remember that other LNOs are coming. We've currently got a second LNO that's simply not fully developed at this stage, but certainly another one in the arena, not just PEXA. So that was, I had to comment on that and say, well, how does that work? And does that really mean that priority notices will supplant caveats at the end of the day? And while looking for what sort of argument you're building in that regard, the reality is they're not going to replace caveats, but as is mentioned, for example, in your casebook, there have been arguments around those. This is on sort of about page 569 to 70. There are arguments being made that that they become more useful than the caveat mechanism. But as many students pointed out, there are good reasons why you might wish to lodge a caveat in different situations that would be stronger protection than the priority notice. But also some students pointed out that in Queensland, and again, this was in Queensland, right, that we're going back to the legislation here. So the legislative process in Queensland for caveats means that you can't just lodge a caveat and then you don't need to do any more. You actually then got to prosecute the matter, and if that, otherwise it will lapse. There are time frames and so on. So, I remember at least a few students pointed out, well, maybe that is a reason why caveats aren't lodged as much in Queensland as they are in other jurisdictions. Yeah, good practical point. So again, in a presentation, you're looking for some practical points to make as well, because clearly partners are interested in that. So, you know, what I would say is that in relation to question one, there was a lot of good work done, but there was also a fair bit of description. So you have to get a balance right between explaining the concepts and articulating those, but keep going back to what the question is focusing on. Keep looking for those keywords, folks. Keep linking your response, your argument back to those keywords and focusing on the task at hand. So in this context, you know, obviously it was priority notices, caveats, e-conveyancing. The priority notices were going to supplant or replace caveats, and a presentation to law firm partners. You're engaging with all of that, well, you would have done well. And there was a range of responses, some really, really good responses, and some not so. Right, so moving on to question two. Now, question two, like question three, a problem-solving question. Question two was essentially a question about how do we deal with a priority dispute between unregistered interests in Torrens land. Because we had a Torrens lot, Kim, the registered proprietor, was the owner of the lot, and she ended up taking out two further loans from two different entities. So basically we had a competition of mortgages for different reasons. Neither were registered, so therefore they were unregistered interests. But the second in time interest by Always Easy finance company, they had lodged a caveat. I thought that the facts are quite clear about that. It says that they've decided to lodge a caveat to protect their interest. That means that they've lodged a caveat. Right? They've decided to lodge a caveat. So I think it's reasonable to take it that that means that they have done that. I was surprised that a number of students actually started to advise Always Easy Finance, which is what you are required to do in this question. Oh, you should lodge a caveat. Oh, really? I thought they had decided to lodge a caveat. Read the facts carefully, folks, okay? That's very important, to read the facts carefully. And the other thing is, you were, again, look at what's required. You were asked to advise Always Easy Finance, right, of their rights under land law against the Gold Coast property. Now, that immediately brought you to, hopefully, to the realisation that you were advising an unregistered mortgagee whose interest was second in time. That immediately then meant that what you needed to think about was, well, the main issue here related to two unregistered interests. You're advising the party that has a second in time unregistered interest. The question then becomes, is there, and because there's not enough money to pay out both loans, is there any way that your client's second in time unregistered interest could get priority in a dispute with the first in time unregistered interest? Because ordinarily, of course, the first in time is normally considered to be in a prioritous situation, but that required you then to look at facts, what was going on, and very importantly, to look at the conduct of the parties. Okay. Now, the fact that one of the parties had lodged a caveat, that is the second in time interest, Always Easy Finance. So I had a number of students decide to spend a lot of time looking at all the processes around caveating and whatever. That really wasn't the focus of that aspect of the question. Certainly you had to talk about the role of caveating, but it was in the context of how that contributed to maybe displacing the first in time unregistered interest holder, S Bank. Okay, but essentially looking at the conduct and the actions of the parties. And then that required you to look at, the case law that also said, well, what are we focusing on? Just the conduct of the first-in-time unregistered interest holder, that is Best Bank, to displace them and allow Always Easy Finance to gain priority? Or do we look at the conduct of both parties? Earlier case law suggested we focus more on the first-in-time interest holder. Later case law, particularly the AGCQ decision and some even more recent case law, which some students picked up on, which was excellent. No, we need to look at the totality of the conduct and behaviour here to work out what is most equitable overall in the end in terms of which interest should take priority. And, and then you need to do a bit of a forensic examination of what's transpired and why was it that Best didn't lodge, for registration. We've got this scam email. They haven't followed up. There was a senior loan officer. Many students picked up on these features of the facts. Good. Then commented, well, that there seemed to be a substantial financial organisation. They should update their antivirus software. The senior loans officer should make further inquiries before deciding not to lodge documents for registration, so on and so forth. And then looking at the conduct of Always Easy Finance, your client lodged a caveat, did a search, nothing was revealed. Well, nothing was revealed because nothing was registered. No caveat had been lodged by Best Bank. So they seem to have done all the right things. And some students also commented on the time frame between when the first interest arose by Best Bank and when the second interest of Always Easy Finance arose. And it was good to look at timing. Time frames can have critical significance in land law, in all areas of law, but land law, because requirements with regard to doing certain things by certain times, lodging documents, registering and so on. So in the exam, think about spending just, even if it's a few minutes, doing a little timeline with the critical dates, critical events and the dates when they occur in terms of whatever it is that's being assessed. Maybe a little diagram that's linking the characters together, if that helps you. All right. Now, that doesn't form part of your answer, but it's a nice little structure that help you move forward. Again, as point, there's a tight time word constraint here, but it's in problem solving. It's very acceptable to have subheadings, again, within the parameters of the exercise. Now, looking forward to the exam, you need to look at how much the question is worth and how much time you have. But subheadings, as appropriate, can focus. It can firstly structure your answer in a nice logical way, but also the examiner can see, right, you've spotted that issue, right, you've spotted that issue. Clearly there are issues that are intended for you to identify and discuss, okay? And the other thing too is that clearly with question 2, and this is also true with question 3, but probably a little bit more so with question 2 because it was very much around analysing case law. You don't, and I know this, for the exam, this is a different thing, and I'll just comment on that in a moment, but just going forward, thinking about doing assignments, if you've still got assignments to do, you've still got units to do after land law, which I assume most of you will have, don't just drop all the case law into footnotes. Right? So yes, of course, you can put aspects of law and whatever in the footnotes, but bring up some of the critical case law into the text of your answer and comment on it and apply it to the facts. Okay? Not just proposition, bang, here's the law, proposition, bang, here's the law. We're looking to see how you're analysing the law and applying it to the situation. We need to see what you are doing with the law, not just as a reference point of authority for a point that you're making. Now, clearly you can't do that with everything, understood, okay, because of parameters, word length, time length, whatever. Be selective. if you think this is a really critical case that's relevant, bring it into the text of your answer and apply it. But again, you don't need to tell long stories about the law, right? So that some students, for example, so I mention a case and then detail all the facts of the case, not necessary, okay? You might need to say a little bit about some features of the facts in terms of how you're saying it governs this situation, but this is where you've got to be both selective and also analytical, okay? These are skills, folks, that you have to grasp and develop as well-grounded lawyers going forward. Property lawyers, yes, of course, property lawyers, but lawyers generally speaking, these are the skills that we need to look at a body of material, body of information, to synthesize it or to summarize it, to bring it down to its essential components, if I put it like that, and then apply it back to the task at hand, to the facts at hand, and so on. Again, there was some very solid work done in regard to question 2. Some where the failings were, I think there were some students that went off on a bit of a tangent with regard to caveats, as I mentioned just when I started making opening remarks around this question, and documenting in detail the whole caveating process. And in some students actually didn't then proceed on to talk about the whole priority dispute issue at all. Well, the question wasn't about that. Right? The question was about priority dispute in regard to unregistered interests. How did caveats form a part of that? Both the act of caveating, which is what your client did, Always Easy Finance, and the failure to caveat, which was the situation for Best Bank as the first-in-time unregistered interest holder. And we had the early case law on that by Barwick in the Just case, and then we had the more recent reflections on that in Black and Garno, and then the contrast of opinion. And the reality is it continues to be an aspect, but it is not even in and of itself determinative. Okay, and that's where the mechanism still essentially the caveat is protective. Okay, but there seems to be more of an insistence upon, well, if you haven't done it, why haven't you done it, sort of thing. Okay, but it's not just the only factor. It's a really important point to point out. And so, overall, just in terms of outcome, I think that based on what Best Bank had done and hadn't done, and based on what the conduct of their officers, employees had done and hadn't done, in contrast to what Always Easy Finance had done, I think it's fair to say that it's most likely that Always Easy Finance would have ended up gaining priority in the dispute, and that the first-in-time unregistered interest holder would have been displaced. Some brief comment could have been made then about what steps next could have been undertaken, but that really wasn't within the intended remit of the question. That could have been done as well. Again, there was some very, very strong answers in response to this question, which was great. And there were also some, rather ordinary responses, as is to be expected, I suppose. So that's question 2. Now, question 3, I think question 3 presented a bit more of a puzzle for some students. And essentially, question 3, hopefully as you would identify, it was about co-ownership. But it had a few component parts. So it was necessary for you to determine and be clear about this. What was the type of co-ownership reflected by the facts? Come back to that in a moment. Then, once we've settled that question, we then need to look at the claims that are being made by Amelia against Joseph's estate. So as the facts reveal, Joseph is now deceased, and it's his executor which is now seeking to do things. Amelia wants to know what her rights are. So you're advising Amelia, and the issues, the facts reveal that Joseph had done things to rent out rooms in the property that both he and Amelia co-owned. So that brought in rent, but they weren't all the same. He also undertook improvements, but those improvements were sometimes in the nature of maintenance, but in other situations they were in the nature of enhancing the value of the property. Much of that was done unilaterally and not discussed with Amelia as a co-owner. But something that many students didn't pick up on was the fencing was discussed, but as some really good answers identified, but it wasn't resolved. Discussed, but not resolved. So you're looking for being a bit forensic in your analysis of the facts. Okay. In terms of tackling the problem, right, so we had that. We also then had another issue that arose was Amelia was out of occupation. Well, what was the circumstances of her being out of occupation, and what were the requirements for her to be able to maybe claim an occupation fee? And did she have to contribute to the improvements? What were her entitlements with regard to a share of the rents which had been received? Was all the monies that were received by Joseph actually rent? This rose the issue in relation to one of the occupants, Janice, who in fact was Joseph's sister. Now, many students just lumped all of those occupants in together. Well, that wasn't right. That information there on Janice was put there deliberately to raise the issue about, well, was that actually rent? And that really threw up an issue of, well, what constitutes rent for the purposes of being able to claim, get a share of that for the other co-owner, for example. And then you had to look at, well, how was the money, how did it arrive, what was it used for? There was information in the question about that in terms of how the monies from Janice was used. So they were the features that needed to be investigated. You're advising Amelia. So again, you're focusing on where, multiple characters in the scenario. Who are you advising? Think about their context. Amelia was a co-owner with Joseph. But that then, and you're looking at rights and obligations. So what were her entitlements? What were her obligations or responsibilities with regard to the property that she co-owned, but which she was out of occupation in? And then, unfortunately, her brother died through an accident, and then there's a dispute with the executor. So what was the type of co-ownership? Well, a lot of students got hooked up here in terms of joint tenancy, and a lot of students decided to give me a bit of a shopping list. Oh, these are all the things about joint tenancy, and these are all the things about tenancy in common. Don't need to do that, folks. You need to work out, just in this situation, what does it look like, okay? And then how do you explain it, and how does the law justify it? You can see that you've been given information about equal contributions to the purchase price of the property. Now, immediately, that should start to alert you to the possibility of a tenancy in common, okay? But then you'll also say that when they became registered proprietors of an estate in fee simple, that the respective shares of ownership were recorded on the indefeasible title. The respective shares of ownership. Well, that doesn't happen in a joint tenancy. Information there revealed in the facts, okay? So this was a tenancy in common situation, but you couldn't just say, oh, this is a tenancy in common. You needed to, show the law that supports that. That required, and this question required you to refer to the Property Law Act, as well as the case law in terms of co-ownership. Also, of course, we're talking about Torrens title land because the lot is in Queensland and it's fee simple under the Land Title Act. So quite rightly, many students pointed out the requirements of the Land Title Act with regard to recording of what type of co-ownership it is. but there are also presumptions now under the PLA, which actually reverses the previous common law position, presumptions in favour of tenancy in common, and that's also now the situation in equity. Equity is always presumed a tenancy in common rather than a joint tenancy. So you then needed to proceed on the basis of a tenancy in common. Now, a number of students didn't get that right. They resolved it to be a joint tenancy. Well, I wasn't going to torpedo a response if, in fact, you were finding a way to argue through the remainder of the issues and cover the relevant law. But clearly, if you started on that track and you didn't identify the right type of tenancy in common, right type of co-ownership, there were going to be issues. Because if, in fact, this turned out to be a joint tenancy, then the property would go to Amelia by way of survivorship. And there wouldn't be any problems with the executor, wouldn't arise because it would go by survivorship. So how would you get to that situation of then being in a tussle with the executor over a property that was jointly owned on the demise of one of the joint tenants? I'm a bit befuddled by that. But anyway, the point was that you needed to resolve that against the law, and some case law is relevant. And then you needed to work your way through those other aspects that I mentioned. So the issue about occupation, was Amelia entitled to claim an occupation fee even though she was out of occupation? And many students correctly pointed out, well, there's a requirement of ouster, but a lot of students decided to stick with historical law on that. There has been more recent case law that suggests a bit of an amelioration, if you want to put it like that, in terms of the ouster requirement, if it's no longer possible for the parties that have this, are in, co-own this property and otherwise occupying it together, to actually continue to co-occupy together, then recent case law suggests that probably is sufficient, but that has been in situations of spousal relationships, de facto relationship situations. This isn't the case here. These are siblings. So the law, the courts might take a different view, but this whole issue of ouster is part of a justification for an occupation fee. And then the issue around improvements and Amelia's having to contribute to those improvements, and whether that adds to the value of the property or is mere maintenance, and whether these were approved or not approved, discussed, not those. These are the features of establishing that. And I've already made some comments about that. And then whether she's entitled to a share of the rent that's was obtained, or the monies for renting out the rooms were obtained by Joseph before his demise. And again, how the law governed that, and this required, sort of an understanding of how the case law has evolved around that, and also the fact that we had occupants in different situations. And again, as I mentioned earlier, the Janice situation, which certainly the facts reveal was different, and was there any justification for treating Janice and the monies obtained from Janice differently to the other occupants? Surprisingly, there were many students that just ignored that and just, as I said earlier, lumped all of those monies that were coming in for occupancy of the rooms, whether they were, in whatever, however those persons had that occupancy rented in a formal way or not. The information around Janice was there as something different, and that needed to be commented on and explored. So again, going forward into the exam, you're looking for information that you're being given that is there for you to think about and comment on in terms of the law's impact. Okay, so in a problem-solving question, you're on the hunt for information and facts that reveal features or aspects that maybe need to be treated differently, and they're put into the scenario deliberately to test the degree to which you understand the application of the law in this area. Okay, so again, going forward into the exam, think about that. Okay, again, as with question 2, it could have been the case that you used appropriate subheadings. Many students, again, chose not to do that. It's fine. Again, word length parameters here, and that's also the case with regard to the exam, not word length parameters, but time parameters. But again, just be mindful that subheadings are useful because they can structure your response and provide a logical sequencing of how you're dealing with the issues. It's easy for an examiner to see, oh yes, that issue's done, yes, that issue's done. But it's important always to spot the issue, make mention back of the facts that identify the issue, bring in the law that you believe is relevant and resolve the issue. What's the outcome? One of the things that I was a little bit critical of in some students was that not really wanting to ultimately make a judgment call in some of the issues that arose. Can't do that, folks. The law might be this way or that. It might be ambivalent. Your client is not interested in ambivalent advice that says, oh, the law is this way and that, and can't really say. The client's not interested in that. That doesn't mean that if you don't feel that there's a strong case, that you don't bring that to the attention of your client. Absolutely. And you may be canvassing the different possibilities here. But as a lawyer giving advice to a client, they're looking for what you say is, in your position of examining the situation at this stage, what is most likely given your understanding of the law. That's really what you're doing, okay? So it's important for you to be as definitive as you can in terms of resolving issues as you proceed. I mean, for example, in question 3, I think that there were at least a few answers that said, oh, well, could be joint tenancy, could be tenancy in common. It's all a bit too difficult. There you go. It doesn't work. We need to know what it is, okay? Just traversing the terrain, that's not good enough, okay? And it gets subject to the criticism of being, a bit all over the place, and not really focusing in on the task at hand and resolving what needs to be resolved and moving on and being clear and more succinct in the way that you're framing your discussion of the issues and application of the law, and then ultimately the advice you're providing to the client. And just lastly, remember, again, in this situation, question 3, you were advising one of the co-owners, and the other co-owner had, deceased, and so the action was against the executor of the deceased co-owner, and some students here took up this, with seriousness and framed their letter of advice to the client. That's great. That's really good. Again, going into the exam, I don't need you to be wasting time. I'm not saying that's a waste of time in the context of this exercise, but I don't need you in the exam to be, doing the formal bits of a letter. That's not necessary, right? Again, time constraint, people, time constraint. But if you're being asked to advise a client, an entity who is a client, then please do that. Advise the client. This is what I advise at the end of the day. Right? That's appreciated. That's what we're looking for. That's what I'm looking for, as well as your tackling of the issues, identification of those, application of the relevant provisions of the legislation and the case law. And the other thing too is, and this is really important, I think, because we've got a case book, substantial case book, as we know, right? Can I suggest that in the areas that are subject to assessment in the exam, that you're getting a balance between some of the historical law but also picking up on some of the recent law, particularly that's relevant in Queensland, okay? Because your questions are set in the context of Queensland legal framework against which this unit is benchmarked. I know I have students in all different parts of Australia, some overseas, and we know that land law, from a legislation point of view, is benchmarked against state-based legislation. But the long and short of it is, this is a course or a unit that is delivered for, as part of your degree studies, for purposes initially of admission to practice in Queensland. So we are doing things against the Queensland legal framework. So your casebook, of course, is a book that's intended for students studying in all jurisdictions, as will have been evident from, as you've seen, reading through it, which is the way that such texts are designed. But what you need to focus on is picking up on both some of the important historical law, but some of the what are the more recent cases and judicial statements, if they've been reproduced, that are relevant in Queensland. What are the critical provisions of the relevant legislation in Queensland, right? That's what you're focusing on, okay? So when you're, as you're continuing your review and preparation for the exam, think about that. And the other thing I just want to encourage you, again, moving forward from the outcome, sort of in terms of the feedback on this particular assessment, try and see what you can produce in a time frame, an exam time frame, right? So 30 minutes, 45 minutes possibly, in terms of thinking about a problem-solving question, maybe the same length time, 30 to 40 minutes, for a policy-style question, and at least have a go at a couple of those type of questions, whether they be the past exam question. Not all of those questions are assessing, those questions assess topics that aren't all assessed on your exam, so be mindful of that. Past tutorial questions, questions from the Q&A book, but have a go seeing, practicing what you can actually write out. All right, so look, the lot of, I think it's fair to say, quite pleasing work in the 30% assessment. And I thought that a lot of you, put in a fair bit of work, which was good. So there we are. There's feedback on the 30% assessment in LAWS12066 Land Law. So, bye for now.